In a rural area in one of Johor's district in Mukim Pulai, there is a village inhabited by the Aboriginal people called the Orang Asli Seletar of Johor. They live on customary territories for so many generations and heavily relying on aquatic resources for sustenance and livelihood. Two of their girls, Saza and Lana, took steps to install 4 signs surrounding Kampung Temun burial grounds. They were put up at different strategic locations around the area so they are noticeable by anyone approaching. It is to alert outsiders of the existence of the graveyards and to warn them against trespassing. However, they were later shocked to find out that there were excavators that are bulldozing their territory. Angered, they figured out that it was Iskandar regional property and also government of Johor who initiated the excavation of their land. In the end, their land was destroyed and left in despair. The Aboriginals consequently been unable to carry out their traditional subsistence and economic activities. There is also risk of poverty and possible extinction of the race. Because it is offensive to them, Saza and Lana got personal and took it to the social media, both on Instagram and Twitter account. They posted their angers and condemned everyone that is involved, including the king of the state, for being noiseless about this matter. As the outcome, their postings received a lot of hate comments and they were later arrested for the action they committed. Thus, from the situation, several issues must be solved. Let's go!
The issue that has resurfaced from the situation given is whether the Aboriginal rights belonging to Orang Asli Seletar pertaining to their livelihood and customary land are protected in the Federal Constitution or not. Fundamental liberties are essential to every human being, for it is the freedom of every person granted from birth in this world. These fundamental liberties cannot be denied in the basis of skin color, ethnicity, religion, age, gender, language, political affiliation, and also social status. It is fundamental to every human existence. Thus, fundamental liberties must be preserved and secured properly under the law. Otherwise, it would render the state as unconstitutional. Fundamental liberties are also to be enjoyed by not only ordinary people but also by indigenous people. Their rights are categorized as the Aboriginal rights and they are recognized by the Malaysian law. This can be seen when it is being codified into the legislation called the Aboriginal Peoples Act 1954. Pertaining to the question, the articles that are relevant to be discussed are Article 5, 13, 8, and also 9. Firstly, this relates closely with the livelihood of a person. Thus, Article 5, Clause 1 focusing on rights to life. On personal liberty, it is prescribed that no person shall be deprived of his life or personal liberty save in accordance with the law. This means that a person gets to enjoy the way of his living as he pleases. He must be allowed to have everything that he needs as a human being, so not to deprive him his own rights. It's very critical and pivotal fundamental liberties that the law could grant to a person, because only through this right one gets to enjoy the other fundamental liberties such as being treated equally, acquiring property, seeking jobs, and so on. Without a life, one could not do anything. In the case of Tan Teck Seng, the word life includes employment and also environment that is free from pollution. This means that it is a critical situation when a person is being denied this right. This is concerning with his continuity of living as a civilized person. To put things into perspective, Saza and the rest of Orang Asli Seletar is entitled to their right to life, and this may include their way of living. They have the legal rights to their life as they could live the way that they want, and any course of livelihood must not be denied. Following the case of Tan Teck Seng, as I have mentioned earlier, employment, a living area that is free from pollution, is amongst the rights to life that they are entitled to. In the simplest way of putting it, their living area must be harmless and safe to be inhabited. However, in this instance, the state authorities have breached their territory regardless of the signages that both Saza and Lana had installed around their burial areas. Not only they ignore the signs that which serve the purpose of preventing anyone from breaching their territory, but also brought harm along with them. The outcome of the state authority had jeopardized the good quality of Orang Asli Seletar's home to the extent that they were unable to carry out their traditional subsistence and also economic activities. It was likely that they would even be driven to poverty and possible extinction through the decimation of the ancestral graves, mangrove forests, and pollution of the rivers and also the coastal waters. So their actions have interfered with their rights to life. Worse, they might as well stop their chains of living. So, because their place of inhabitation has been destroyed by the state authorities, their livelihood is deeply affected and worse, stopped. then this has denied their right to life and hence violation of fundamental liberties by virtue of Article 5, Clause 1. The next fundamental liberties that have been breached by the defendants is Article 13, Clause 1 on the rights to property. Provided therein in the Clause 1 of Article 13, no person shall be deprived of property save in accordance with the law. This article provides that a person has the liberty to acquire property, meaning that he or she has the rights to own their lands, houses, cars, and so on. As such, when a person acquires property, they have the proprietary rights over their property and no other person shall interfere with their property, such as breaking their property, destroying them, harming them, or making the property gone. The word deprive in the provision is very much significant because it shall mean that a person should be enjoying his rights to property without anyone stopping them without any lawful reasons. Breaching this would amount to violation of fundamental liberties. However, if the circumstance deems so, for instance, their property is being destroyed and their property is being taken away from them, they are entitled to compensation as provided in Article 13, Clause 2. Usually, it is a situation where the government must occupy the land belonging to a person for the purpose of a country's development, for such that they want to build buildings or shop houses on the land. So, the government must compensate the owner of the land sufficiently as in accordance with the law. This is because when they are taking away the land, they are depriving the person's right to his property. Compensating them only then would stop the deprivation of the person's right to his property. The landmark case of Adong bin Kuau and others against Kerajaan Negeri Johor and another, the courts took into account the fact that the original sum would involve deprivation of land use for a person for no special attachment to the land and upon which the land he does not depend on for his livelihood. This means that the judge there valued the land based on the several considerations, namely the deprivation of heritage land, deprivation of freedom of inhabitation or movement, deprivation of produce of forest, deprivation of future living for himself and his immediate family, and finally deprivation of future living for his descendants. So what actually happened in this case? The defendant, by agreement with the government of Singapore, acquired land to construct a dam to supply water to both Singapore and Johor. The representatives of Aboriginal people living around the catchment area sought declarations that the lands acquired were an Aboriginal area or Aboriginal reserve and that they were entitled to compensation. So later on, it was held at the court that the Aboriginal people's common law rights over the land include their rights to move freely about their land without any form of disturbance or interference, and also to live from the produce of the land itself. In Malaysia specifically, the Aborigines' common law rights include that the right to live on their land as their forefathers had lived, and this would mean that even the future generations of the Aboriginal people would be entitled to this right of their forefathers. The plaintiffs had both common law Aboriginal rights and statutory rights under the Aboriginal Peoples Act 1939, and they were entitled to compensation under the legislation under Article 13 Clause 2 of the Federal Constitution. Therefore, back to the question, Saza and Mana and the rest of Orang Asli Seletar have been officially recognized as an Orang Asli village by the government. Thus, they are entitled to rights to life and of course right to property. In fact, they have been occupying their lands for eons, given that it was their ancestral lands. Saza and Lana seem to understand their rights when they put up the signs of preventing outsiders from intruding in their territory. This is because they would want to keep harm away from their property. Yet, the Iskandar Regional Development Authority and the Director of Land and Mines for the state of Johor have trespassed into their land without their permission. Furthermore, following the case of Adong bin Kuau, as I have mentioned earlier, they have the rights given by the common law to live on their land as their forefathers had lived, and this would mean that even the future generations of the Aboriginal people of their kind would be entitled to this right of their forefathers. Thus, it can be well established that there is indeed a violation of rights by virtue of Article 13 Clause 1. Saza and Lana and the rest of Orang Asli Seletar all have the rights to be compensated adequately as per according to Article 13 Clause 2 and also as had been decided in the case of Adong bin Kuau.
Next, Article 8, Clause 1. Everyone is entitled to equal protection of the law, since everyone is seen as equal. Everyone is the same. Relating to the situation of Aboriginal rights belonging to the Orang Asli Seletar, pertaining to their livelihood and customary land that are protected in the federal constitution or not. In this situation, since they are the Aboriginal people, so their race tend to be discriminated, as we can see that nowadays that people are neglect the Aboriginal people, so that if their rights have been violated by such act, this can be seen as a form of abuse and oppression. They are subjected to the Article 8 and thus must be treated equally as any other race of people. So it means that no matter what race you are, so we need to treat people equally. They must have the equal protection by the law, safeguard and preserve their rights to life and also their customary land that is rendered as their property. According to Article 9, Clause 2, every citizen has the right to move freely throughout the Federation and to reside in any part thereof unless there is any other restriction imposed by the government, such as due to public order, public health, or punishment of offenders. In the situation of this case, their ancestral activity cannot be done, which is they freeze their movement and the orang asli cannot be able to move around freely in their own territory as given by the provision. However, the ruins of their homes caused by the state authority have immobilized the orang asli to even move freely in their own place. As a result, this has violated their freedom of movement. To conclude, the orang asli Seletar have been deprived of these fundamental liberties, especially their rights to life. In essence, that the rights of orang asli lie in our federal constitution, certainly in the Aboriginal People Act APA 1954 and in common law as an extract native customary rights. These rights may not be as strong in protecting the rights of the orang asli since it can be easily extinguished with compensation, especially in the light of the unprecedented development in our country. However, it does provide legal recognition to the position of the orang asli as the original land settler of our country.
Okay, now, in order to answer question B, first, we need to take a look at the issue. The issue that has arisen in this question is whether Saza and Lana's action exceeds the right given to them by the Federal Constitution under freedom of speech, and they can be charged under the Sedition Act 1948. Article 10, Clause 1A of the Federal Constitution clearly stated that every citizen has the right to freedom of speech and expressions. Among the forms of speech and expression are word of mouth, signs, symbol and gestures through the works of art, music, sculpture, photograph, films, videos, books, magazines, and etc. However, if you look further to the Article 10, Clause 2, it says, Parliament may impose restrictions as it deems on the following grounds, such as security of federation or any part thereof, friendly relations with other countries, public order, morality, privilege of Parliament or of any legislative assembly, contempt of court, defamation, incitement to any offence, questioning of any matter like right, status, position, privilege, sovereignty as in Article 4, and subversion and emergency. All this is done to maintain harmony in Malaysia. Among the things that can undermine harmony in Malaysia using speech and expression is sedition. Because of that, in Malaysia, we also have the Act to provide for the punishment of sedition, and we call it originally as Sedition Act 1948. According to Section 2 and Section 3, Subsection 1 of the Sedition Act 1948, any act, speech, words, or publication are seditious if they have a tendency towards any of these things. Firstly, to bring into hatred or contempt or to exercise disaffection against any ruler or government. However, in 2015, Parliament has amended this section by deleting the words or against any government. That is why it is now called as Sedition Amendment Act 2015. Secondly, to assign subjects to seek alteration other than by lawful means of any matter by law established. Thirdly, to bring into hatred or contempt the administration of justice in the country. Fourth, to raise discontent or disaffection among the subjects of Yang di-Pertuan Agong or of the ruler of any state or amongst the inhabitants of Malaysia or of any state. Fifth, to promote ill will and hostility between races or classes. And lastly, to question the provision dealing with language, citizenship, the privilege of Malays and native of Sabah and Sarawak, and the sovereignty of the rulers. The uses of these things can be seen in PP against Param Kumarasamy 1986. In this case, it was held that intention to incite violence, tumult, or public disorder is not a necessary ingredient of the crime, as long as the words were internationally published and they had the tendency to cause ill will, the offence is complete. For those who make the seditious tendency as what I have said just now, then under Section 4, Subsection 1, he or she shall be guilty of an offence and shall on conviction be liable. For the first offence, they will be fined to a fine not exceeding 5,000 ringgit or to imprisonment for a term not exceeding 3 years or 2 years. And for a subsequent offence, there will be imprisonment for a term not exceeding 5 years. Furthermore, any seditious publication found in the possession of the person or used in evidence at his trial, it shall be forfeited and may be destroyed or otherwise disposed of as the court wishes.
Regarding the application, we found that Saza and Lana has deliberately violates the limitation of publication and Seditious Act 1948. One thing that needs to be noted that the same at the face of any government has been deleted. So meaning that Saza and Lana has violated Section 3, Clause 1, Clause A, which to incite any disaffection towards any ruler only. So the previous version of the Seditious Act 1948 provided any publication to the government as well, and ruler was not prohibited. The same act has been revised and amended, and any wrongdoing or publication to any ruler is considered illegal. Then it mentioned in their tweet about the Sultan of Johor for not taking any action upon what had happened to them. The tweets caused chaos in ruling party politician, and the public was stated that several demonstrations was held by the NGO as a sign of outburst. The tweets, I would say, can be deemed as seditious, as it had caused disaffection towards the ruler and chaos. Well, we can relate this in the case of PP against Param Kumarasamy. Statement was made during a press conference, calling on the Pardons Board to reconsider the commutation of death sentence for Sin Ki Chon. Mr. Kumarasamy was acquitted on the ground that his criticism was directed to the Pardon Board and not against the king. It was held that intention to incite violence, turmoil, or public disorder is not necessary ingredient of the crime. So the next my point is again on Article 10 of Federal Constitution. Regarding the Article 10 of Federal Constitution, Saza and Lana might use it as a defense to their action. Well, every citizen has a right to freedom of every citizen have a right of freedom of speech and expression. They will provide an Article 10 and Article 10 Clause 1 Clause A. You can see this in the case of Muhammad Fahmi Reza, Muhammad Zarin against public prosecutor. The defendant has published a caricature of former Prime Minister Najib Razak. Well, the most important part of the case was the intention of the defendant, whether to really express his thoughts or to intend of hurting others. Well, he was convicted under Section 233 of Communication and Multimedia Act and was found guilty. And next of the legal consequence of the action of Saza and Lana was provided under Section 4 of the Seditious Act. They shall be liable for first offence to a fine not exceeding 5,000 ringgit or to imprisonment for a term not exceeding 3 years or 2 years.
Next, in answering question C, we need to take a look at the issue. The issue that has arisen in this question is whether Saza's and Lana's detention was unconstitutional and their right was being denied under Article 5, Right to Life. Article 5, Clause 1 of the Federal Constitution clearly stated that no person shall be deprived of his life or personal liberty save in accordance with law. According to the case of Kantek Seng against Suruhanjaya Perkhidmatan Pendidikan, employment, health and free from pollution are included in the meaning of the life. Moreover, the court in the case of Adong Kuau and others against Kerajaan Negeri Johor and another stated that right to livelihood is included under the rights of life. Furthermore, Article 5, Clause 3 of the Federal Constitution stated that where a person is arrested, he shall be informed as soon as may be of the grounds of his arrest and shall be allowed to consult and be defended by a legal practitioner of his choice. And lastly, Article 5, Clause 4 says, where a person is arrested and not be released, he shall, without unreasonable delay, and in any case within 24 hours, excluding the time of any necessary journey, be produced before a magistrate and shall not be further detained in custody without the magistrate authority.
Article 5, Clause 3 is an article that has been given to an arrested person to ensure that their arrest was lawful. Article 5, Clause 3 has been invoked so many times on several different cases when discussing on the fundamental liberties on an arrested person. One of the cases is the case of Nick Adli bin Nick Abdul Aziz against Ketua Polis Negara, whereby it has been established that the refusal and failure to inform the detainees on the ground of their arrest is a form of violation to their personal liberties. In other words, an arrested person has the right to ask the officer on the ground and on what reason that they have been arrested for. Next, a person being detained has the right to consult and be represented by legal counsel of his choice. This is illustrated in the case of Oi Aqua against officer in charge of criminal investigation, Kedah Police, whereby has been said that the right of an arrested person to consult his lawyer begins from the moment of his arrest. To further explain this, it means that a person that has been arrested can request to see a lawyer of his choice. Failure to comply to this request can make the arrest unlawful and make the officer to be liable for unconstitutional arrestment. Next, let's talk about Article 5 Clause 4. Article 5 Clause 4 gives the right to an arrested person to be produced within 24 hours before a magistrate. An arrested person must be produced before a magistrate within 24 hours. These 24 hours exclude the time of necessary journey such as transportation of an arrested person. An arrested person also cannot be further detained without the authority of the magistrate. In other words, an arrested person needs to be produced before a magistrate after his arrestment. Failure to comply or failure to produce him within 24 hours before a magistrate infringe his right that have been given under this article, which makes his arrestment unlawful after 24 hours. Now, back to the question whether Saza and Lana's arrestment was unconstitutional. Based on the evidence and the situation, we can establish that there are three violations to their rights as an arrested person. One of them is they were not informed of the ground of arrest. Saza and Lana, when they asked the detaining officer about the ground of arrest, they were ignored by the officer. This infringed their rights under the Article 5 Clause 3. Secondly, they were also denied the right to consult a lawyer. Both Saza and Lana, they requested to see a lawyer, but they were also denied. This contradicts the rights to be represented by legal counsel under Article 5 Clause 3. Thirdly, they were also not produced before a magistrate within 24 hours. The failure of the authority to bring Saza and Lana before a magistrate within 24 hours deprived the constitutional right. This can be seen as they were detained on 3rd March of 2017 and they were only produced before a magistrate on 5th March 2017 at 2 p.m. This is more than 24 hours, which is the time limit that have been given under the Article 5 Clause 4. So, based on these three violations to their rights, it can be seen that their arrestment was unconstitutional and unlawful. In this case, the authority, they failed to acknowledge both Saza and Lana rights as an arrested person under the Article 5 of the Federal Constitution. Now, as Saza and Lana, what can Saza and Lana do to seek justice for their unlawful and unconstitutional detention? In this case, we discussed that Saza and Lana may take legal action. Both of them have the option to pursue legal action against the detaining agency on the ground that their arrest was unconstitutional and the detention infringed their rights as a person. The legal action that they may take is that to file for habeas corpus, which is for Saza and Lana to be produced to a court. In this court, they are going to be judged on whether their detention was unlawful and unconstitutional. In this court, the question may arise on whether their rights under Article 5 of the Federal Constitution as an arrested person were infringed by the detaining agency and officer. As we discussed earlier, there are three rights that were infringed by the detaining agency. First, they was not informed of the ground of arrest. Secondly, they were denied to request to see a lawyer or consult a legal counsel. And thirdly, they were not produced before a magistrate within 24 hours. So, Saza and Lana, they may take legal action and argue on their rights, on these three rights that they have been infringed by the officer when they were arresting them.